Welcome to the deep dive. Today we're tackling a really high-stakes legal question that arose from literal flames: the defense of necessity in tort law. Imagine this scenario. San Francisco, 1849. The city's basically built of kindling, and this massive fire breaks out. An official makes a terrifying call: blow up private buildings with gunpowder to stop the fire spreading. The owner sues him personally for $65,000, which was, an absolutely enormous sum back then. So the question is, was that legal? Is destroying private property justified to save the public? And importantly, who pays? We're digging into a landmark case, Sirocco v. Geary from 1853, born right out of that disaster. Our mission: figure out if an official acting in good faith in an emergency is personally on the hook, or if the responsibility shifts somewhere else. To really get to the heart of this conflict between necessity and property rights, where do we need to start our analysis?
Okay, yeah, we absolutely have to start with a core distinction here: public necessity versus private necessity. It sounds straightforward, maybe, but it's not. What's really fascinating, and maybe a bit counterintuitive, is how the law ends up classifying blowing up a house to save a whole city. That classification is everything. It dictates liability, it dictates compensation.
Okay, public versus private necessity. Got it.
So our path today is this. First, define the rules, really zeroing in on that public-private split. Then we apply those rules to the Sirocco case, using that structured fire act analysis you know. After that, we'll use a pretty intense hypothetical the court itself used to really cement the idea. And finally, we'll wrap up with a step-by-step checklist for you, the listener, to spot this issue effectively.
Great. Let's lay down the basics first. Before we jump into Sirocco, what is the general rule for this necessity defense? And critically, how does the law draw that line between public and private necessity?
The general rule is, at its heart, pretty common sense. An actor is justified in interfering with someone else's property rights, doing something that would normally be a tort, like trespass or destroying property, if they do it to avoid a greater imminent harm.
Right, like self-preservation, but for property or a community?
Exactly. But the public versus private distinction, that's where the money is, literally. It controls who pays, if anyone. Now, an act of necessity, even by a public official stopping a huge fire, is not the government exercising eminent domain. That's the constitutional power to take private property for public use, which always requires just compensation. Necessity operates differently.
Okay, so it's not eminent domain. How is it different then, especially when it feels like it's for public use?
Here's the subtle but crucial legal reasoning. If the destruction is done for the public benefit, but it's primarily acting as a police power measure stopping immediate danger, and the direct benefit flows mainly to the specific people whose property is saved from that danger, then the law classifies it as an act of private necessity. Even though the whole city benefits, the immediate legal beneficiaries are those adjacent property owners.
Wait, hang on. That feels backwards. Alcalde Geary was the mayor, acting for the city council, saving the whole city. Why call that private necessity?
That is the absolute crux of the Sirocco decision, and yeah, it seems weird at first glance. The court saw it this way. While the effect was public safety, the legal mechanism wasn't the state taking property for its own use. Instead, it was about destroying property that was already doomed by the fire anyway, primarily to save other private property nearby. It's seen as protecting the collective interests of those private individuals in that specific emergency. The state isn't acquiring anything.
Okay, that's a really fine distinction. Protecting private interests collectively during a crisis, not the state itself taking something. Let's test this right away. Let's look at Sirocco v. Geary. Remember, the defendant is John W. Geary. He was the first alcalde, basically the mayor or chief magistrate in San Francisco, acting with advice from the local council, the Ayuntamiento, during that huge fire in December 1849. Okay, let's analyze Sirocco v. Geary. First, what are the legally dispositive facts?
The facts are pretty dramatic. The plaintiffs, Sirocco and others, sued Geary personally, not the city, him, for $65,000. Why? Because he ordered their house and store blown up with gunpowder, destroying everything inside. Geary's defense was pure necessity. He argued the building was right in the fire's path, it was certain to be consumed anyway, and crucially, leaving it standing would have let the fire jump to adjacent buildings, making the disaster much worse. And the key evidence supported this. The fire actually reached the spot where the building had been just a very few minutes after it was destroyed, so destruction was imminent regardless.
So the building was doomed anyway, and blowing it up saved others. Got it. And what was the core legal issue the California Supreme Court had to decide?
The precise legal question was this: can a public official, or even a private person, acting in good faith to stop a massive fire, destroy a building without being personally liable for the damages?
What rule did the court apply to answer that?
Well, California in 1849 was in transition. The court noted that the law of Mexico was still influential, specifically referencing a very old Spanish legal code, the Seven Partides, Title 15, Law 10. And that old law was surprisingly clear. It explicitly said someone who, in good faith, destroyed property to stop a fire was not liable for damages. The court also added that, hey, this isn't just some old Spanish rule. The same principle exists in common law. It's a generally accepted idea.
Interesting how they pulled from multiple legal traditions. Okay, so what was the court's analysis? How did they apply that rule to Geary's actions?
Their analysis focused on Geary's intent and the situation's reality. They stressed he wasn't acting for personal gain, but to save the city. They definitively classified it as private necessity, not eminent domain. Why? Because the property wasn't taken for public use, it was destroyed because it was already lost to the fire, and its destruction benefited other private property. The standard they used for justification was important. Was the action judged necessary by the judgment of discreet men who have knowledge of all the circumstances? And was it done with a good intention? Since the evidence showed the fire would have destroyed the building anyway, and blowing it up prevented wider loss, the court found Geary acted reasonably and justifiably.
And the conclusion, what was the final outcome for Alcalde Geary?
The conclusion was clear. The destruction was justified under the doctrine of necessity. Therefore, Alcalde Geary was not personally liable for the damages.
So he wins the appeal. The initial $7,500 verdict against him was overturned.
That's right. The Supreme Court said the trial court got it wrong.
Okay, now here's where it gets really visceral, connecting this abstract legal idea to something primal. The court used a striking analogy to explain why this was private necessity. They compared destroying the building to, well, they said it was like that which authorizes the appropriation of a plank by one which will not sustain two in the water. Ah, that's a dark image. Two people, one plank, only one can survive. How does that grim picture illustrate why blowing up a building to save a city is considered private necessity?
It illustrates it perfectly, actually, despite being grim. It highlights the idea of choosing to save one private interest, your life on the plank or the neighbor's houses in the fire, at the necessary expense of another private interest, the other person's life, or Sirocco's house. In both scenarios, the actor isn't the state taking something for general public works. They're making a forced choice between competing private interests in the face of imminent disaster. The law recognizes the necessity of that choice and protects the actor from liability because it's fundamentally about preserving some private value against total loss.
Okay, that clarifies the private aspect. It's about the immediate beneficiary being private individuals or their property, even if the overall effect benefits the public.
Exactly. And this leads directly to the big so what question, compensation. If Geary isn't personally liable, does Sirocco just eat the loss? The court says no. They point towards the principle of general average.
General average. You mentioned that sounds like maritime law. Can you break that down? What does it mean here on dry land during a fire? How does it help the person whose property was sacrificed?
You're spot on. It originates in maritime law. Imagine a ship in a storm. Cargo is thrown overboard, jettisoned to save the ship and the rest of the cargo. When the ship reaches port safely, the value of the saved ship and cargo is assessed. And everyone whose property was saved contributes proportionally to compensate the owner of the cargo that was sacrificed. It spreads the loss among the beneficiaries.
Okay, so the court is importing that idea.
Precisely. The court is saying Sirocco isn't without recourse, but his lawsuit needs to be aimed differently. He can't sue Geary, the actor. Instead, the court says, those whose property was saved because Sirocco's building was destroyed, they reap the benefit and ought to contribute. So Sirocco, or someone in his position, could potentially sue the owners of the saved properties for contribution based on this principle of general average. The burden shifts from the actor to the beneficiaries.
That makes a lot more sense from a policy perspective. It avoids punishing the person making the tough call in the moment, but it doesn't leave the victim completely high and dry. It spreads the cost across those who directly benefited.
That's the core policy logic behind it.
Okay, this has been a fascinating deep dive, weaving together Spanish colonial law, common law, and emergency powers. For you, our listener, the learner, how do we boil all this down? If you encounter a necessity problem, say on an exam or even analyzing a modern event, what's the step-by-step framework?
All right, let's synthesize this into an actionable diagnostic checklist. If you're faced with a potential necessity defense, follow these 5 steps. Step 1. Identify the threat. Was the harm truly imminent and inevitable? Was that building really certain to be consumed? Necessity requires immediate, unavoidable danger. A speculative threat isn't enough.
Okay, imminence and certainty. Step 1.
Step 2. Determine good faith and discretion. Did the actor act with good intentions? Was the decision reasonable based on what discreet men, knowledgeable people would judge necessary given the circumstances at that exact moment? It protects reasonable crisis judgment, not malice or recklessness.
Good faith and reasonable judgment under pressure. Step 2.
Step 3. Classify the necessity. This is the trickiest part we discussed. Is it the government acting under eminent domain, requiring state compensation? Or is it an act of private necessity, even if benefiting the public, broadly done under police power, primarily to save other private property from imminent harm? Remember, Sirocco put stopping a conflagration firmly in the private necessity category for liability purposes.
Classify. Eminent domain or private necessity, police power. Got it. Step 3.
Step 4. Determine actor liability.
Yeah.
If you've established steps 1, 2, and 3, imminent threat, good faith, private necessity, then the actor, whether they're a public official like Geary or a private citizen, is generally not personally liable for the damage caused.
Actor not liable if 1, 2, and 3 are met. Step 4.
Step 5. Identify compensation source.
Right.
Critically, the analysis doesn't stop there. The person whose property was destroyed isn't necessarily left with nothing. The claim shifts. Compensation should be sought from those who benefited from the destruction, the owners of the saved property, under that principle of general average or contribution.
Compensation source,
Yeah.
the beneficiaries via general average. Step 5, that's a clear framework. What an incredible example of how the law navigates impossible choices during disasters, forcing this detailed accounting of who owes what to whom. Sirocco shows that necessity justifies the act, but the loss itself might still be shifted.
Absolutely. And if you think about the bigger picture, the core policy in Sirocco isn't really about giving officials immunity. It's about finding a mechanism, general average, to shift the financial burden from one person, the actor or the victim, onto the broader group that directly benefited. Which leaves us with a final thought for you to consider. How well does modern society actually implement this principle today? In our complex world of disasters, insurance, and government aid, how effectively do we manage to make the beneficiaries contribute equitably when necessary actions cause unavoidable damage? Something to think about.